Alright, yan. Magandang araw mga kabatas natin at welcome sa isa namang live stream. Mga kabatas natin, nagbabagang balita rin. Ano ho? Itong Anti-Terrorism Council, mga kabatas natin, ay dinesignate na terorista. No, itong si Congressman Arnolfo Atty. Teves at yung kanyang armed group as terrorist group of persons, organizations, or association, and its members as terrorist individuals. Okay, mga kabatas natin. So ito, no, ang date niya July 26, 2023. Sabi niya, no, ito yung mga whereas clauses lang naman, ito yung dahilan o yung purpose ng Anti-Terrorism Act. Sabi dito, no, Section 45 of Republic Act number 11479 or the Anti-Terrorism Act created the Anti-Terrorism Council to implement the ATA. Blah, 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 blah. So meron ng Anti-Terrorism Council. Yung Anti-Terrorism Council, mga kabats natin, siya yung nag-declare as terrorist dito sa grupo ni Teves. Sabi niya, whereas paragraph 3 of section 25 of the ATA states that the ATC may designate an individual group of persons, organization, or association, whether domestic or foreign, upon a finding of probable cause that the individual group of persons, organization, or association commit or attempt to commit or conspire in the commission of the acts defined and penalized under sections 4, 5, 6, 7, 8, 9, 10, 11, and 12. Mag-ahos natin, magandang gawin natin dito, no? Tingnan natin kung ano yung effect. No? Anong epekto nitong pag-declare kela Teves, no, at yung kanyang grupo na terrorist. Pag makikita nyo kasi dito, mga kabatas natin, ito yung mga tao. No? Now, therefore, the council, by virtue of the powers vested on the ATC, pursuant to blah blah blah, blah sections, no, ito yung mga tao na dinesignate as terrorists. Okay? Yan, si Congressman Arnolfo Teves, si Pride Henry A. Teves, Marvin H. Miranda, Rogelio C. Antipolo, Romel Pataguan, Winrich B. Isturis, John Louis Gonyon, Daniel Lora, and Eulogio Gonyon. Okay, so ito yung mga particular violations nila yung nandiyan sa gilid. Ngayon, ang hindi kasi pinakita dyan, mga kabatas natin, kung ano yung magiging epekto niyan. No? Nandito yan sa implementing rules and regulations ng Anti-Terrorism Act. Ito kasi, mga kabatas natin, yung rule 6.3, ha? Sabi niya, domestic designation by the ATC through a determination of probable cause. Ito yung ginawa nila. Ito yung sinight nila, no, rule 6.3.3. Ito yon, no. For purposes of designation under 6.2 and Rule 6.3 and for proposals for designation under Rule 6.8, probable cause shall refer to a reasonable ground of suspicion supported by circumstances warranting a cautious person to believe that the proposed designee meets the requirements for designation. Ibig sabihin, may probable cause na terorista daw sina Teves. Okay, sabi ng Anti-Terrorism Council. The ATC shall adopt mechanisms, blah, 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 blah. So ito, mga kabatas natin, ang effects of this designation. The assets of the designated individual, group of persons, organization, or associations under the act shall be subject to the authority of the Anti-Money Laundering Council to freeze pursuant to Section 35 and 36 of the Act and Section 11 of Republic Act number 10168. So, ibig sabihin yan, mga kabatas natin, yung pera nila sa bangko, no, sa mga institusyon kung saan nagtatago ka ng pera, ma-freeze yan. Okay? Sabi niya, all designations made under this rule shall not be dependent upon the pendency of any criminal proceeding against the proposed designee. Tapos yan, mga kabatas natin, epekto rin ng designation, no, ipapublish ito. Kaya nga, yun, dineseminate na. Posting, publication, dissemination, and notice of designation. All ATC resolutions of designation shall be published, posted in a newspaper of general circulation, on the online official gazette, and on the official website of the Anti-Terrorism Council. A list of designated persons or entities shall be published posted on the official gazette and the official website of the ATC, which list shall include the following: the name of the person or entity or other identifier information, a brief description of the case for the designation, the date of designation or date of last review of designation. Okay? Yan. Effectivity of designation. The designation made under Rule 6.1 shall be effective until the designated individual, group of persons, organization, or association has been removed from the UNSC consolidated list. The designation made under Rule 6.2 and 6.3, ito yung 6.3, ito yung kay Teves, shall be immediately executory and shall be valid from the date of publication of the corresponding ATC resolution in the online official gazette and the official website of the ATC. Okay, ito, periodic review. The ATC shall conduct a review every 3 years to determine if the basis for designation under Rule 6.2 and 6.3 still exists. The ATC may consult with and collect information from relevant law enforcement agencies or from other foreign jurisdictions to support the review. Ito yung pwede nilang gawin. Ito naman yung mga pwedeng gawin ng mga Teves ngayon para matanggal sila. Request for delisting. Okay? Dito sila sa 6.2 and 6.3. Ngayon, pwede sila mag-file ng verified request for delisting before the ATC within 15 days from the publication of the designation. So, within 15 days lang. A request for delisting may be filed as often as the grounds therefore exist. Hindi, pwede naman pala. However, no request for delisting may be filed within 6 months from the time of denial of a prior delisting. Hindi ko alam kung tama yung terminology dito kasi sinabi niya a designated party or its assigns or successors in interest may file a verified request for delisting before the ATC. Siguro after 15 days from the publication of the designation. Kasi usually laws, mga kabatas natin, take effect after publication or 15 days after publication. Pero pwede naman, a request for delisting may be filed as often as the grounds therefore exist. So, ibig sabihin, hindi lang within 15 days from publication pwede magpa-delist. Pwedeng paulit-ulit ka mag-file ng delisting even after the 15-day period, pero not within the 6 months from the time na nag-request ka ng delisting. So, sa tingin ko, typo ito. Typo itong nasa taas. Kasi pwede ka mag-file ng delisting or request for delisting anytime, hindi lang within the 15 days from publication of the designation. The request shall set forth the delisting as follows. Ano kaya pwede maging ground nila? Mistaken identity? Syempre hindi. Relevant and significant change of facts or circumstance? Syempre hindi. Newly discovered evidence? Syempre hindi. Death of a designated person? Syempre hindi. Dissolution or liquidation of designated organizations, associations, or groups of persons? Syempre hindi. Any other circumstance which would show that the basis for designation no longer exists. F. Pero ito, ibig sabihin, mayroong designation pa rin eh. Dapat yata meron naman dito na parang wrong designation, ganun. The basis for the designation is wrong. Di ba? Wala eh. Walang the basis of the designation is wrong. For designations made under Rule 6.2, the request for delisting shall be accompanied by proof of delisting by the foreign jurisdiction. 6.1, di tayo dyan eh. 6.2 and 6.3 tayo. Yun iba na. Pero dapat madagdagan pa ito. Kasi ang mangyayari kasi dito, hindi ka pwedeng magpa-delist pag wala dito kasi A, B, C, D, E lang eh. Pero dito sa F, any other circumstance which would show that the basis for designation no longer exists. Ibig sabihin, nag-exist siya noon. Dapat A, B, C, D, E, F, dapat may G, any other circumstance which would show that the basis for designation is not existing or does not exist. Di ba? Di ba? Parang ito, oh. Yung wrong designation, wala. Di ba? Yan, oh. Yung wrong mistake na designation, wala. Pero I think they have to go for the request or they have to request for the delisting. Tapos, ang procedure sa tingin ko dito mangyayari dyan, because this is new. Wala pa sa tingin ko ang dumadaan ng ganito, no? So, I think ang mangyayari dyan, you have to request for delisting. After mo nag-request ng delisting, pag na-deny yan, yun, pwede ka nang umakyat hanggang Supreme Court kasi nga, syempre, may judicial review. The court has the power of judicial review. Di ba? Sabi niya, marami nagsasabi matatransfer na muna daw ni Teves yung assets niya bago pa ma-freeze. Posible ba yung attorney? Well, pag inaabangan niya ito, kasi sinabi na sa kanya yan eh. Sinabi na sa kanya yan noon na parang i-declare siya, di ba? Linabas, parang pinakita ni ni Department of Justice Secretary Remulla yung barahan niya noon nung sinabi niya na gumagawa sila ng paraan para ma-declare as terrorist. So I think baka may nangyari na. May nangyari ng lipatan ng pondo kasi nga hanggang hindi naman hinahawakan ng AMLA yan. Wala namang hindrance o pwedeng pumigil sa pagta-transfer ng kanilang pondo. Diba? Yun nga, sabing ganyan, appropriate ba yung Teves terrorist drug? Kawawa naman yung individuals na may surname na Teves kahit wala namang kinalaman sa kaso. Well, yun yung ginawa nila eh. Yun yung linagay nilang tag, diba? So, I think they have to question it. I think they will question it definitely. Yan, mga kabatas natin, maraming salamat po sa inyo. At syempre, tulad ng laging sinasabi, matulog po tayo ng mahimbing dahil alam natin na yung natutulog ng mahimbing, siya yung laging panalo. Paalam po pansamantala. Saan yun?